With these questions in mind, Joseph Paulus begins to prepare for jury selection in the case against John Andrews. Despite the lack of physical evidence, he's apparently quite hopeful of his ability to win the case. In fact, he tells reporters, "My experience as a prosecutor for 8.5 years is that circumstantial evidence is often more compelling and convincing than direct evidence." He goes on to say that direct physical evidence can create discrepancies in stories, conflict with minor details that are not as firmly implanted in the minds of witnesses, and generally cause some confusion in the case. It can certainly become tedious at times and remove the emotional aspect of a murder that often captures the attention and focus of those serving as jurors.
Yeah, I can buy that. So the case is headed to trial and a jury's being selected. But just as jury selection is about to begin, Milwaukee-based defense attorneys Stephen Glynn and Dean Strang, Dean would later rise to fame for representing his client Stephen Avery in another infamous Wisconsin murder case chronicled in a wildly popular Netflix series, submitted a motion to the court asking for a change in venue. They want the jury to be selected from a pool of individuals who live outside of Winnebago County, which includes both the cities of Neenah and Oshkosh, Wisconsin. Arguing that the local media has published numerous stories about the case over the prior decade, including many which focus on John Andrews as a person of interest, attorneys Glynn and Strang state that the local jury pool in Winnebago County is incapable of providing an unbiased assessment of Andrews' guilt. In their motion to the court, they write that a Winnebago County trial, quote, will be impossible or will be unreasonably expensive because of the extensive pretrial publicity by radio, television, and print media outlets in the Fox River Valley area.
I think it's a fair argument for the defense to make. This has been a high-profile case since the time that Swenson first went missing in 1983. But it's also important to note that there have been several years before John Andrews' arrest during which little, if anything, was published. The case was cold, with hardly any new evidence being brought to light at all for around 6 years prior to the sudden break in 1993. The judge in the case, Circuit Court Justice Robert Hawley, rules against the defense and states that jurors will be questioned individually prior to selection. As part of this, they'll be asked whether they have any prior knowledge of the case, as well as other routine questions such as whether they believe they are able to offer an impartial ruling apart from any personal judgments that they may hold. Judge Hawley does tell defense attorneys that they are free to submit another motion for a change of venue if, during jury selection, it seems difficult or impossible to identify jurors who state they are unaware of the case due to its profile in the media.
Along with this, John Andrews' defense team submits one other motion to the court. It's one that's more complicated, but also one that is potentially much more damaging to the prosecution. The defense submits a motion asking the court to exclude any testimony from the John Doe hearing held not long after Starkey Swenson went missing.
If you remember from our earlier episodes, the state in 1984 conducts a John Doe proceeding, a type of hearing that's unique to Wisconsin, in which the prosecution is able to call witnesses as part of an effort to determine whether a crime has been committed, without having to disclose evidence to the defense team. There really isn't a defense team yet. The hearing in 1984 was held with John C. Andrews as the clear person of interest in the case. Investigators asked Andrews a lengthy list of questions about the events on and after August 13, 1983, in order to determine whether he was involved, which of course he denied. As the trial is prepared to start in 1994, Andrews' defense team writes a scathing motion against the John Doe proceeding, arguing that it's a highly suspect way of dealing with someone who is the subject of possible prosecution. Dean Strang goes so far as to state that John Doe proceedings in general are unnecessarily secretive, likely setting up further appeal against this investigative tool in case Andrews were to be convicted in the trial, arguing that the secrecy is broader than any I'm aware of in federal court. He also notes that Andrews had been subpoenaed to appear at the proceeding, only to be asked to essentially testify against himself.
In response to this, District Attorney Paulus stated that great pains had been taken to protect Andrews' Fifth Amendment rights, that he was aware of his legal options during the hearing, and that the testimony should be admitted. Justice Hawley agreed, once again siding with the prosecution and ruling that details of testimony given at the John Doe hearing should be admitted at trial. I can't say this is at all a surprise to me. Regardless of any personal opinion any of the attorneys involved in the case may hold, John Doe hearings are Wisconsin law, and their entire purpose is to assist in an investigation. It would be entirely out of place for the circuit court to rule that this testimony is inadmissible in a trial that resulted from an investigation that included such a hearing. I agree with your thoughts that the defense is, of course, anticipating this and is setting up the possible case for an appeal should John Andrews lose his argument at trial. As an interesting aside to our story, it's worth mentioning that in the years that have followed our case, John Doe hearings have remained a hot-button legal and political issue in Wisconsin. In 2015, the state passed legislation significantly limiting the scenarios in which a John Doe hearing can be used. The viability of John Doe hearings even made its way to the Wisconsin Supreme Court that year, related to investigations into the campaign of Governor Scott Walker. The court voted to suspend the John Doe hearing in that case.
So back to the Starkey-Swenson investigation. Judge Hawley rules against both motions submitted by the defense, and the case is once again headed for trial in Winnebago County, beginning with jury selection. In addition to noting that jurors will be questioned thoroughly before selection, Justice Hawley also indicates a high likelihood that he will order the jury sequestered during trial. He states he would plan to do this in order to insulate them from the inevitable media swarm that will cover every aspect of the trial once it begins.
Not too much more happens before jury selection, which takes place on March 14, 1994. Both prosecutor Joseph Paulus and defense attorneys Stephen Glynn and Dean Strang are permitted the ability to dismiss 7 jurors for various reasons. This is in addition to Judge Hawley's option to dismiss any jurors whose answers to questions from any of the attorneys or the judge himself indicate a prospective juror may not be capable of unbiased judgment in this matter. Jurors are asked a number of questions as part of the screening process, including whether they know of anyone or have themselves been involved in an affair, whether they believe a body is needed to prove that a murder occurred, whether they have been the victim of a crime, and if so, if the perpetrator was brought to justice, and also whether it's important to always tell the truth or if there were legitimate reasons to lie and that truthfulness can be graded on a sliding scale based on the situation. In the end, 14 jurors are selected from the initial pool of 56, including 6 male jurors, 6 female jurors, and 2 alternates. All members of the jury are ordered to sequester in the Hilton Hotel in Oshkosh. They're asked to refrain from reading, viewing, or listening to anything related to the case, and are told to keep silent about any matters they hear in their capacity as a juror in the Starkey-Swenson murder trial.
In the next episode, we will cover the trial of John Andrews and learn more about his guilt or innocence and the possible location of Starkey-Swenson's body.
One more item before we go. If you have any questions about the Starkey-Swenson case to this point, our show, or the investigation, please submit them to us via our social media channels or our website, frozentundrapodcast.com, as we'll be releasing a special bonus pod later this week, answering many of the questions our listeners have submitted. Additionally, if you want to know more about the Starkey-Swenson story, we highly recommend you visit our website or follow our social media channels on Instagram, Facebook, and YouTube for additional information, behind-the-scenes footage, and more. We will continue to post insider content and updates as this real-time investigation progresses. You can find our social media pages using the links on our website or by searching for us on our social media platforms. We'd like to take a moment to thank those who helped us compile information on this case, including the Winnebago County Sheriff's Department, newspapers.com, and individual citizens who've shared their knowledge. Our theme music was created by Mario Cole 06 and is available for download from Pixabay.